struck, and that we have indeed perfected over time, to include recognizing the rights of people that we excluded wrongly. This Constitution has great resilience, but it has also been frayed by court decisions and inaction and overreach, altogether somewhat contradictory. But I know this. Last year we had our first grandson, and the thought has crossed my mind 10 or 15 years from now, when he's old enough to begin to understand some things. And if we don't take this action, what will his world be like? What will the balance that our founders wanted for true federalism look like? And when he asked me, "Granddaddy, what did you do during the great constitutional crisis when our freedoms were threatened?" I'm going to say, I fought back.
The gentleman from Prince William,
Pass to third reading.
Mr. Marshall.
We pass the resolution.
Speaking to the measure.
Has the floor.
Thank you, Mr. Speaker. Mr. Speaker, I appreciate what I believe are the intentions of the gentleman from Prince William to address some of the, what we both would agree are abuses or directions that we don't want the country to go in, but I really question the method here. This is an article several years ago by a gentleman, Mr. Speaker, at one point you co-authored an article with him in the Wall Street Journal. This is Randy Barnett, and he is a law professor at Georgetown University. Now, he says an amendments convention is feared because the scope cannot be limited in advance. The convention convened by Congress to propose an amendments to the Articles of Confederation produced instead an entirely different constitution under which we now live. Yet it is precisely the fear of a runaway convention that states can exploit to bring Congress to heel. Now, this is an article from the Columbia, Missouri newspaper from last year, and it's referencing a state senator, Kurt Schaefer, who's proposing one of these amendments, Convention of States project. He's talking about efforts to limit expenditures for campaigns and a term limits, or a balanced budget. He says these two propositions are not really exclusive. He says, quote, "My feeling," I don't know about his judgments, but he's telling us about his feelings, "is that once a convention is called, we will have to have some sort of grand bargain, such as the Convention of 78. Now, Mr. Speaker, I'm holding in my hand the iPad here, which references a listing of convention applications current, and if you go to the clerk of the House of Representatives in Congress, you can find this. This is a reference to a request for a balanced budget amendment to the Constitution pursuant to Article 5. It was received by the clerk of the House in 2016. Well, when was this measure passed? It passed March 7th, 1978 in their state House, and in their state Senate, April 26, 1978. So I guess the mail is a little slow from Missouri, Mr. Speaker. Additionally, I asked Congressman Goodlatte, who's chairman of the Judiciary Committee, do you have rules, standards, procedures, whatever, for counting, excluding, or including applications for a constitutional convention call? I wrote a letter to Chairman Goodlatte. I wrote a letter to Chairman Grassley, senator from Iowa. I didn't get a response from either of them, so I got to using my finger, made a phone call, and talked to an assistant to Congressman Goodlatte. They didn't want to put anything in print, but they acknowledged they have no rules. It is totally wide open as to how these things will be counted. So, Mr. Speaker, here's an application from 1978. Does this satisfy at least the decisions of the Supreme Court that actions must be somewhat contemporaneous? I don't think so, but the clerk of the House posted an application passed 37 years ago on the clerk of the House of Representatives website. Is this to be counted? Well, there's no indication. It just is there. Mr. Speaker, the original Constitution was devised under the Articles of Confederation. Now let's talk about what changes were there, how radical they were. The Articles of Confederation had term limits. This Constitution doesn't. Under the Articles, you could recall a member of Congress. This Constitution doesn't. Under the Articles, you voted by state. This Constitution doesn't, except for one condition, one circumstance, when you're voting for the Electoral College. Nowhere else do you find a requirement that the members of the House resolve themselves into states for purpose of voting, and it's one state, one vote. Is there a term of office changed? You were a congressman for 1 year under the Articles. You were a congressman for 2 years or a senator for 6 years. The composition of the legislature under the Articles was only a House of Representatives. Under the new Constitution, there was a House and a Senate. States could form treaties with the consent of Congress. Virginia can't do that now. Nobody can. States could send ambassadors to foreign nations. Can't do that now. The direct taxing of citizens was not allowed. That is allowed under the new Constitution. There was no judiciary under the Articles other than the Congress. Under the new Constitution, it's a separate judiciary. Disputes between the states were decided by Congress under the Articles. They're now decided by the Supreme Court. The militia was under the balance of state control. Here it may be federalized. The war powers, Congress plus 3/4 of the states. Now it's just Congress. Issuing bills of credit, Congress plus 3/4 of the states. Under the new Constitution, not specified, but greenback paper money was issued in the war between the states or Civil War under the war powers. Borrowing money required Congress under the Articles plus 3/4 of the states. Here it's just Congress. The size of the Army and Navy was determined by Congress plus 3/4 of the states. Here it's determined by Congress. A treaty or alliance was Congress plus 3/4 of the states. Under here, it's the present Constitution, it's the Senate. An amendment was unanimous by Congress and the states. Here, it's 3/4 of the states. Mr. Speaker, this is a significant shift in power. This was what was called simply amending the Constitution. Even Mr. Madison acknowledged that they acted based upon the revolutionary powers asserted in the Declaration of Independence of the right of any people, and it's correct, to change their government. But they clearly exceeded a number of the instructions. So while we just passed I think a lifeboat that's full of holes, I don't know that we can take any comfort in that bill. We have any number of legal experts on both sides of the ideological spectrum saying you cannot limit a convention. We are gambling with our future, much worse than holding elections for members of the House and the Senate. Mr. Speaker, there is no certainty here other than there's nothing certain about this. And to think that Congress is going to form itself under the rule of the states, well, it's about a 1,400-page book, which I have idle time and I read these things. What is this? This is a hearing on Constitutional Convention procedures, November 29th, 1979. Every bill that I saw for calling of a convention and the organizing of it was pursuant to the powers for Congress to implement the enumerated powers. None of them had the Constitutional Convention or our convention of, amendments convention organized by states, voting by states. It was voting by individual. The selection process was equal to the number of electors you have from a state, and that was it. But when you got to Congress, you were on your own. Even Mr. Nadelson, who's one of these gentlemen who supports this, acknowledged that even if you formed yourself in states to get to this thing, and again, there's no resolution requiring that you form yourself by states that the states are sending to Congress, nor is it binding. You could change it once you're there. Mr. Speaker, this is a pit of uncertainty, even though there are genuine motives that I believe are, of goodwill. We need not gamble with our Constitution.
Gentleman from Charlottesville, Mr. Toscano.
Thank you, Mr. Speaker. Speaking briefly to the measure. Thank you, Mr. Speaker. Ladies and gentlemen of the House, the gentleman from Prince William has articulated some reasons for why we should do this, and let's just accept that he is right on his analysis. There are some of the points I agree with, some that I don't. The other gentleman from Prince William has made some pretty cogent arguments as to why this would be dangerous. The risk of a runaway convention, the risk that we not only get rid of the Second Amendment, but we get rid of the First Amendment. There are a lot of risks. But all I want to do is leave this chamber and see if you can answer this quiz. Ready? Your mission, should you decide to accept it, is to determine which Supreme Court justice articulated these words. Quote, "I certainly would not want a constitutional convention." Whoa. Who knows what would come out of that? So the question is it Justice Ginsburg? How about anyone want to raise their hands on that one? Or Justice Antonin Scalia? Thank you, Mr. Speaker. I hope we'll defeat the measure.
Before I call the next person, has anybody in here not made up their mind yet? The gentleman from Fairfax, Mr. Lemonnier.
Thank you, Mr. Speaker. Speaking briefly in favor of the resolution.
Gentleman has the floor.
I just make 2 points. One, it's fascinating to talk about the convention in Philadelphia in 1787 and what went on there and the Virginians that were involved in that. But I would just respectfully submit that whatever happened at a meeting 230 years ago has no bearing on a meeting that might be held in the 21st century. I mean, if we're really concerned about that, just think of some things this body did in the 1860s, the 1950s, but we still come and meet. We're not afraid to get together as a General Assembly. We're not bound by what happened in the past. We're bound by what we know now and can take into the future. I'll also call attention to the fact that there are some people who think that the questions resolving rules of a convention can never be answered. I think you heard that from the gentleman from Prince William. There are others of us who think that they must be answered. There is a group of state legislators from more than 30 states who have gotten together on several occasions to draft rules of a convention. You can go on the internet and see them. It's work in progress. I don't agree with pose an amendment to the Constitution that's not included in the applications will be ruled out of order. It all looks like it would be a session of some legislative body in some state in America. Very calm, cool, collected, and normal. I hope we'll support HJ3. Thank you, Mr. Speaker.
Shall the resolution be adopted? Clerk will close the roll.
Ayes 52, noes 47.
Ayes 52, noes 47. The resolution is adopted.